PTV app.
Taking a company to court is something most of us don't ever want to have to do, but it is a fundamental right that we certainly want to know we have.
Right, and you need to know a few things about it, but thanks to legal maneuvering, many of the companies we use every day are taking away that right without us even realizing it. And here today with what you need to know is Fox 29 lifestyle expert Shari O. Always good to see you, Shari, especially when it's about our rights, right? How on earth are we being denied our day in court without us even knowing it?
Sure. Well, they're called binding arbitration clauses, and they're appearing more and more in all of the contracts we sign every day for cell service and credit cards and bank accounts, insurance, just about everything. Essentially what they say is if you have a dispute with the company, you agree to waive your legal right to go to court, and instead you'll let an arbitrator decide the case. The problem with that is arbitrators are everyday citizens, oftentimes lawyers or maybe retired judges, but they depend on their business from future referrals from these companies, so there's a conflict of interest. Not only that, they're not bound by the same rules as judges, and these are private proceedings. Unlike a court proceeding, there's no public records afterwards, and here's a biggie, they're binding. There's no appeal process. So folks are not aware that they're even signing these clauses, but even if they know that the clause is in there, they don't understand what arbitration means, and the impact are significant.
Wow, you do have to read the small print, huh? Because that's what it is. We've gotten lazy. So even though they may pop it up there,
well,
and
and
you look at it, okay, blah, blah, blah. Yeah.
Sure.
And they get sneaky.
So kind of give us your next tip in there.
So, well, in terms of the long-term implications, I'm really concerned about this because we know that this is essentially taking away the right to class action suits. And when big companies do something wrong, John, they don't do a big thing. They do a little thing, maybe a $30 banking fee or an erroneous roaming fee for your cell service. They do it to millions of people, though, but it's too little for one of us to stand up for that. So we know that some significant policy changes have been made as a result of class action suits. That possibility is going away. We also know that most people don't actually use these arbitration clauses because it's too expensive to arbitrate. So, for example, over a 5-year study, Verizon has almost 60 million customers. There were only 5 or 6 people who actually arbitrated over that 5-year period. So the long-term impacts are really significant, even if you're not going to be someone specifically involved in this. They have kept companies honest.
All right.
All right, so that's the long-term impact as well that it has for all of us.
Right, and what everyone really needs to do, we need to read our contracts, know if they've got these arbitration clauses in them. If they do, write a letter objecting to it. Some of the clauses allow you to opt out within the first 30 to 45 days. You need to do that. Congress is already on it, but this is a big consumer problem with long-term impacts.
All right,
well,
Shari.
It's good to know Congress knows about it. That's a step in the right direction.
Now we need to know about it.
We know about it, and let your congressperson know about it as well, that you know about it. Good deal.
Fox 29 lifestyle expert Shari O. Thank you very much.
We'll be right back.